Good evening. Thank you everyone for joining us. For those who don't know me, my name is Paul Baker. I'm a certified financial planner based here in Dubai. I've been in Dubai now for nearly 6 years. Originally from Durban, I then spent 6 years in Cape Town, and now I've been here for nearly 6 years. Doesn't mean we're going to be leaving. We plan to be in the UAE indefinitely, so we don't have one of those 6-year kind of bugs. I'm living here with my son and my wife. My son is 5 years old, so all the issues that we're going to be discussing today are things that are applicable to me and my family planning. And that's why I just thought it's good to actually have this discussion with Luna, who is the go-to wills drafting person that I work with. So Luna and I have been working together now for just over a year. She's been in the Middle East for about 2.5 years herself. She's a seasoned legal practitioner, having more than 11 years experience in private and in-house legal practice. She's previously practiced in South Africa as a senior attorney and was co-director of a law firm back in SA. Despite having moved to the UAE, she remains an active member of the Legal Practice Council of South Africa and holds the right of appearance before the superior courts in SA. In the UAE, Luna is also a recognized legal practitioner before the courts of the Abu Dhabi General Market or Global Market, as well as the courts of Dubai International Financial Center as a registered wills draftsman. Luna is also legal chief officer of a reputable US and Middle East based group of companies. She too is the founder and managing director of Prescient, a legal and cyber intelligence firm in the UAE, which is how we draft all of our wills. When Luna is not working, she's blessed to spend time with her husband Andrew and their 3 special needs dogs, which she wanted to mention, 2 of whom are proudly South African born and bred, and they're all living their best lives here in Dubai. So Luna, thank you for joining me.
Paul, thank you so much for having me and for the kind introduction, and just a warm hello and good evening to everybody. Thank you so much for joining us, and we're happy to have you together with us on this call.
Awesome, thank you. Now, before we go into the actual talk that we've prepared, I have had a lot of requests and questions about the new laws which have been announced in Abu Dhabi this week.
Yes.
So could you just confirm who that affects and possibly how it will affect them?
Of course, Paul, thank you so much. And I'm really pleased that you have brought this topic up. So on Sunday, the 7th of November, this past Sunday, hot off the presses came this announcement that Sheikh Khalifa bin Zayed Al Nahyan had issued this new law to govern personal status matters of non-Muslim foreigners in the Emirate of Abu Dhabi. Specifically, this law was intended to govern various personal status matters of foreigners who are non-Muslim, along the lines of marriage, divorce, the paternity of children, custody, guardianship, and then also specifically relevant to our discussion this evening, inheritance matters. The law specifically now recognizes that non-Muslim foreigners who live, work, or who are domiciled in Abu Dhabi will have this law automatically apply to them unless they specifically exclude its application through election of adoption of the laws of their home country. So it's either this law, or if you specifically exclude this law so as to adopt the laws of your home country, then those laws will apply, but only if specifically adopted. If not adopted, then this law does apply. So in the context of inheritance law, it recognizes specifically the right of a non-Muslim foreigner to draw up and execute a valid will, and in terms of such a will, to distribute their estate however which way they wish. And it further provides for non-Muslim foreigners who die intestate in the Emirate of Abu Dhabi. So if they die without the execution of any valid will, it follows a more traditional and common law type of approach, bringing the law in line at least with international best practices in relation to intestate succession, whereby they say that a spouse is entitled to a 1/2 share of a deceased person's estate, and followed then by their children, then parents, and then siblings of their deceased. So there are arrangements now in place for non-Muslim foreigners within the Emirate of Abu Dhabi so as to properly effectuate and execute a will, or to then elect the application of the law of their home country and exclude the application of this personal status law, or then in the alternative, if a person does fail to actually validly execute such a will, then what is to happen with their intestate succession arrangements.
Okay, so one thing I read there in terms of the translation that I had a look at, it mentioned so one half would go to the surviving spouse, one half would go to the children, but then which slightly confused me now, is if there were no children, then it said it would go to the deceased parents. Now, would the surviving spouse still get a half, or if there's no children, she wouldn't get, or he wouldn't get anything?
The surviving spouse would still get a half. So it would only be if, so the surviving spouse would get a half, and then the other half would actually devolve to the parents. Or if there was no spouse, a surviving spouse, then everything 100% would go to the parents. If one parent was deceased, then it would mean that that parent's half share would go then to the siblings and etc. So it's a common devolution scheme that I'm quite familiar with. We have the same back in South Africa in relation to intestate succession. So you basically draw a family tree and you go up levels or horizontally as may be applicable. Okay.
Good. And then did they make mention of guardianship in that announcement?
They do. They make mention of guardianship, and specifically in relation to the paternity of children, but generally just in relation to inheritance. They say that a testator has the right to freedom of testacy, which essentially just means that they can govern their deceased estate whichever manner they choose. So meaning therein they will have the full right of testacy in relation to any assets that they do have, and then in relation to making decisions in respect of the guardianship of minor children.
Okay, so from what you're saying, from what I read, essentially it would still be important for someone who, a non-Muslim expat living in the UAE, to have a will to make sure that both the guardianship follows their requests or their wishes, and also the distribution, if it goes 100% to the spouse, not 50% and then 50% to the children, which can be a bit, should we call it, difficult or clumsy if the children are minors.
Absolutely, Paul. Look, it's always the, for lack of a better word, it's always the responsible choice to make. And why I say that is because we actually each have such a responsibility to plan ahead and plan for these things, because it is inevitable that we all shall pass away. But what we can do in mitigation of the repercussions thereof is we can put in place certain arrangements as to what is to happen after our passing. So in that respect, also, we need to consider that we have the specific right given to us. We have the right to freedom of testacy. And by direct extension thereof, this gives you the right to include as well as exclude certain persons from participating in the devolution of your estate, and also specifically to have the ability to make arrangements for the distribution of your estate, prepare also for the efficient effectuation thereof, mitigate against the possibility of possible exposure of loved ones during their mourning, actually, of your passing, also to prevent against possible fraud or misappropriation in relation to your assets or interests that you do hold. Too many aspects of a person's estate is left to the application of law or at the mercy of a court system, rather than just simple administration in court in accordance with a drawn legal document, which essentially is a will. So one makes that decision. Do you want to leave it up to the application of the law and put the court system into play, or rather than just go the administrative route in saying just, administer my estate in accordance with my written and pre-vetted and registered wishes?
Okay, awesome. I think we're both on the same page in that regard. So now let's get into some of our talking points that we put together. And firstly, because there might be some people who don't understand some of the basics, so would you just run through and briefly describe what a will is for us?
With pleasure. Paul, so simply a will is a legal document whereby any person can govern the distribution of their deceased estate. meaning they can choose whom is to benefit from their estate, whom is to be excluded from the benefit of their estate. They can determine what is to happen in relation to the guardianship of their minor children. They can govern what is to happen with their mortal remains, their bodily remains, and when I speak in this context, they can perhaps elect a legal option of organ donation in the UAE. They can elect for the cremation of their mortal remains, burial in a non-Muslim graveyard, or repatriation of a cadaver to another location, such as a person's home country, so as to be given to their family to bury. All of these things can be governed in a will. What it is important to understand is that a will is a living document, meaning thereby that it can and it also should be changed in any which way, shape or form relative to a person's personal circumstances. So as a person changes and as their circumstances changes, so should a will. And those changes can take the effect of an actual withdrawal of a will, meaning it can be cancelled or it can be supplemented and changed at any time. And there are certain procedures available to make this easily accessible in doing so in the UAE.
Okay, good. So we've spoken a bit about the changes in Abu Dhabi and how that's going to affect distribution of assets and inheritance. Could we run through how Sharia law would apply and the inheritance and what distribution of assets would look like for an expat based outside of Abu Dhabi once that comes into force, who does not have a registered will, so effectively dying intestate in one of the other UAE emirates?
With pleasure, Paul. So I'm happy you brought this up as well, because there is a very common misconception following the publication last year and exactly one calendar year prior to the announcement and promulgation of this most recent personal status law in the Emirate of Abu Dhabi. There was in fact an announcement made by the government that it would be enacting a law or a change in the law that would govern inheritance matters in the UAE, so UAE-wide, not just limiting it to the Emirate of Abu Dhabi, which would say that the laws of your home country would apply in case you pass away without leaving a will. So it's important to please understand, and I'd love for everybody just to be aware that this law has never ever been drafted or effectuated as yet. So the current status is still the application of Sharia law outside of the Emirate of Abu Dhabi. And the Sharia law of inheritance is basically the equivalent of the common law in the United Arab Emirates. Essentially, and in answer to your question, Paul, it governs inheritance in the UAE, barring certain other laws, and it provides, for example, that if a woman's husband passes away, that she is only entitled to a maximum of 1/8 share of her husband's estate. If the couple, however, have no children, then the wife's share could rise to as much as 1/4. However, this is a discretionary decision. There's also a discrepancy regarding the inheritance of a girl child as opposed to a boy child, because a boy child is entitled to a greater share than a girl child would normally be. Also, Sharia law of inheritance can determine what is to happen in relation to the custody and guardianship of minor children. So custody, very important, is basically the physical location and legal location of a child, the whereabouts, in whose custody a child is. The guardianship, however, is the equally important consideration thereof, but involves more the well-being of a minor child in relation to their finances and their needs, their schooling, medical treatment, all of those decisions that are made. So just to decipher between the two, under Sharia law, a mother shall have the right to have a child's custody in the case of dispute of custody, unless a judge decides otherwise, if it is in the child's best interest to do so, but then also only up to a certain age. So it's generally up to the age of 10 for girl children and younger for boys children. Thereafter, what happens is that the custody can be automatically and by law, automatic operation of the law, be given to the father, or if the father is absent or if the father is deceased, then that child can actually be taken away from the living mother and given in custody to the closest male relative of the father. So as you can see, that these can have far-reaching effects in relation to a mother, a father, and the children.
So just while we are on that point of the guardianship, and it is something that is very important I wanted to raise with you, but in practice, so there's one thing under Sharia law and principle, this is how it would be applied. In practice, if we had a non-Muslim expat living in Dubai, mm-hmm. and the husband passed away and the children were 15 and 17, mm-hmm. would the court say that those 15 and 17-year-old children need to go and live with the nearest male relative? Would they take those children away from the biological mother in that kind of scenario?
So, Paul, in that scenario, the court will always have regard to the child's best interest. However, there is the right of that child actually to be taken away. And what I have seen in practice often fuels this is the fact of financial interest or gain. Because if we look at guardianship again, what will happen is that, in fact, if that child inherits anything from that deceased parent, that guardian will actually take over those assets on behalf of the child, and they will have the responsibility to administer those assets on behalf of the child. And the living parent or the mother then would have no control there over. She would have no say in relation to their schooling, their medical care, and essentially also their custody. So even though they could be physically situated with a mother. So let's say, for example, a closest male relative may say that they may stay there. Their financial interest of that child may remain, and the decision-making interest may remain then as guardianship with the closest male relative of the father. And I have seen this actually happen. I've seen this happen in the most sophisticated of families where, in fact, there was an uncle living in Canada who chose to exercise his right over the children, and he had the children taken away earlier this year from their mother here in the UAE. They'd grown up in the UAE, lived their whole lives here, and they're now teenagers, and they were taken to Canada without the mom having any say.
Sure. Okay, so just reinforces the need for having that will in place.
Absolutely, and more importantly, Paul, I'm sorry, I forgot. I had omitted to mention is that for persons of Muslim descent, this may be a more understood principle, but for persons that are more au fait with the common law way of thinking, and particularly, you know, us as coming from South Africa or any other more Western jurisdiction, these principles are incredibly foreign to us and are nonsensical in the sense that they are applied, whereas to other persons it may make perfect sense. You know, it's the same for, I'll give you its equivalent as well. In terms of Sharia law, if a man and a woman that were married become divorced, essentially what is to happen is that the man gives back the woman to her father, and she becomes the financial responsibility of her father. So, like I said to you, it's completely things that are very foreign towards us, but it's known more in their culture, and the understanding is there, whereas for us it could be something very traumatic and unnecessary and unintended, of course.
Of course, I don't think anyone would intend that in that kind of situation.
Correct.
While we're on this topic, I am following the questions that are coming through, and one of them has just come through, but relating to this specific thing, where the distribution of the assets. So if the wife is receiving 1/8, do you want to just elaborate on the rest of that, the share? So the other 7/8, where would they go?
Absolutely, yes. So with pleasure. So just as one would draw a family tree, you can do a calculation, and I invite everybody actually to do this exercise. Online, you can find Sharia inheritance calculators, and one of them actually exists on the website of the Dubai International Financial Center courts. And therein they will ask you to enter what is, so let's say, for example, you are married, but you are a male, you're a father, and you have 2 children, and you have a living wife. Then what the law says is that your wife can receive a maximum of 1/8 share. The children likely will receive, possibly a male child can receive anything up into a quarter. A girl child will also probably receive 1/8, and the rest will be distributed to parents, aunts, uncles, nieces, nephews, cousins, everybody. It can go far and wide. It's not to say that it by necessity will, but the principle in Sharia law is that everybody should have a share. And the problem comes into play is where somebody actually comes into the picture and lays stake to a claim in relation to your estate. So be it a long lost cousin or whatever the case may be, the court may actually entertain such a claim to such a person's interest and stake in relation to your estate simply by measure of their lineage and relation to you. So it all depends, and there are Muslim bodies and Sharia bodies that do govern these types of matters. So there is a matter of discretion that is also applied, and then of course the court can intervene also in relation to these types of matters. But just in simple answer to the question, it would go where it will need to go until there is nothing left in relation to the distribution of those assets. But it will essentially go from a spouse to children, then up to parents, and from parents to their children, so meaning siblings of the deceased, etc.
So it can be quite a convoluted, and I would imagine that can also delay the process, because that can take quite a bit of time for all those people that come forward that need to publish that and wait for their responses.
Correct.
Now, I know someone in the South African community recently published on Facebook after her husband passed away, and she recommended everyone should get a will. And she just mentioned that she's gone down the election of Sharia law, but then has obtained kind of letters from certain people that could benefit, saying that they do not want to inherit from the will. So obviously that is possible, but it's not always the case. And you might have a cousin or a family member who actually says, well, I'm a bit short on cash at the moment. I don't know what his estate was worth, but I know he was living a great life in Dubai. Let me put my claim in. So it's not something you want to have up in the air.
Absolutely not, Paul. And I mean, I've seen it firsthand as well, of how things can be reversed here. So what immediately springs to mind is that, yes, although those letters may have been issued now, what if they are retracted later and an actual claim is laid against the person who then did receive such an inheritance? You know, it's just leaving too many things to chance. And also I can imagine that an exercise to go about that and request these letters is not something simple either. So the question does remain, and it begs the question, do you want to leave your spouse or any person who may stand to inherit from your estate? Do you want to leave them in such a volatile position at the end of the day, or would you rather just distribute the assets in accordance with your testamentary wishes and do so in a regulated fashion?
Agreed. And look, I also dealt with a lady once whose husband, she was married to an Egyptian who was Muslim. They were married here, they had a child, and her husband passed away. And I know I saw her a few times, and let me rephrase, I didn't see her. I met with her a few times to certify documents and help her with a few things. And she had received, her father-in-law had to go to the courts in Egypt to sign a letter saying that he gave permission for her to travel with their son and to make decisions regarding schooling and all those kinds of things. But of course, that letter can be rescinded at any time. So that's just something to be aware of.
Absolutely, Paul. And what that immediately says to me as well is that the guardianship decision lays with the father-in-law.
Yeah.
And that puts, great restrictions, on that woman and the child. So let's say, God forbid, she one day cannot afford, for one or other reason, to remain living in the UAE and decides to go somewhere else. That family back in Egypt may make the decision to say that that child has to go to Egypt to live with them, or may not give permission that he go elsewhere. So again, it just creates a lot of volatility.
Okay, and just one more question on the distribution of assets, because we've spoken about it from the husband's side. If the wife dies, it's very similar, it's just that the husband would effectively get twice as much as the wife would normally get.
That's right, up to a quarter share for everyone's interest, yeah.
And then it would still include the children and parents and relatives. So it's still an open-ended net, but I would definitely, it's marginally better. The only positive that I can understand, and you can just confirm, that the husband would be the guardian of the children. So he would be responsible for managing their inheritance, and he would also still be responsible for any decision-making regarding their schooling and travel and all of those affairs.
Absolutely, Paul. So yes, a male does have the stronger right in law if left to the application of Sharia law, and they do recognize that. So naturally, children are seen to have to be with their father, and their father would be their caretaker and decision maker, etc. Okay,
awesome. So now, just as a point, so everyone understands, what assets would be included in that UAE estate as part of the distribution?
So, Paul, in relation or in the context of a UAE estate, it would be all movable and immovable property which is physically located within the geographic boundaries of the United Arab Emirates, or any interests which a person may have in the United Arab Emirates. So, strictly speaking, assets, when we're just speaking about assets, we speak of movable and immovable property. And I know your question specifically speaks about assets. What I mean in relation to interests, however, extends a little bit further than just assets. It could also be your parental interests in relation to guardianship and custody, etc., over children, and which you can similarly govern in relation to a will. But coming back to assets, so all movable and immovable property, this includes any, for example, traditional items. Let's speak of motor vehicles, homes, jewelry. Let's speak of other new age items. What about cryptocurrencies and investments in digital assets that people may have? Other investments that they may have, bonds, inheritances that they may receive. And then also, very importantly, not forgetting any death in service or end of service benefits or gratuity benefits that are governed and payable in relation to the labor laws of the United Arab Emirates. So, Paul, you may know as well as I do that often we do get the question, but what if I don't have anything here? People feel that they don't have anything. Fact remains is that if you do stop working, there could be, in favor of your estate, still either a death in service benefit or an end of service or gratuity benefit that is due, and which will then be payable by your employer under the labor laws of the United Arab Emirates, and your estate will be the beneficiary thereof.
As well, yeah, your final salary, all of that, bank account, so all of those things, yeah.
All of those things, absolutely.
Don't get me started on crypto, because if they put on a cold wallet and forgot their codes and stuff like that, that essentially dies with the person who bought it.
Correct.
So that's good. And look, we've gone through the next point, which is just in terms of the bequests and who you can actually bequeath that to. But if you put a will in place, essentially you can bequeath it to anybody.
Absolutely. What I would just like to highlight there, though, Paul, is that a specific bequest is an item or an article that you give to a specific named person. And this is essentially taken as an item from your estate and given to that person. Whereas, an alternative is then what is left after those specific bequests have been given effect to. So One example of a specific bequest, one which I dealt with earlier today as well, is what is supposed to happen to my pets. So pets are seen as assets, they're seen as movable property for all intents and purposes, although they are our fur children. Any pets that you may have. So you may say as a specific bequest that I make a bequest that they be given and be placed in the care of a specific person together with a cash amount or something for their maintenance and care, whatever the case may be. But that's essentially removed from your estate before everything is then tallied. And then thereafter, there are the payment of your lawful debts, administration costs of your estate, any burial, cremation, body repatriation costs, etc. All of those costs considered, then whatever remains in the bucket is considered to be your residue. And you can then make a decision in terms of your will as to what is to happen to your residue and how you'd like to divide that residue amongst your beneficiaries. Okay,
brilliant. Now, I just want to circle back around because you brought up the fur babies. So that, I think, including a clause in that, because unfortunately the sad reality of pets is that they can pass away. Would you include a clause that any pets that we have at the time of our death would go to these people? You wouldn't say Coco and Charlie. You would kind of leave it open-ended just to, again, in the way that you draft all of my clients' wills, they are on an open-ended basis.
Yes.
So that it would cover all assets in the UAE at the time of your death, so that we don't have to keep changing it if you buy a new car or a new, you buy and sell a property and stuff like that.
Absolutely, Paul. So, we can always create a clause to say that we include Coco and Charlie, but not to the exclusion of any other pets that you may have at that time. And the reason we do so, you use the word keeping it open-ended, and open-ended is not to be misconstrued as just leaving it open haphazardly, but rather as a safety net, because what we want to intentionally do is just to future-proof your will and to make its applicability extendable to the furthest end that is possible, and that being in your favor to do so. So unless your intentions change, your intentions will be given effect to as matters would stand at the time of your passing.
Okay, awesome. So again, coming back to fur babies and now moving on to human babies. And that would be the guardianship. And there's another question coming in here just about that, if if both parents die. But so let's just in the case of one parent dying, realistically, the guardianship or the custody would pass to the surviving spouse. Then guardianship would go according to what we discussed earlier from a Sharia law point of view. But now let's just talk about a more severe case with both parents passing away. And if you can just elaborate on how the temporary guardianship and permanent guardianship would work and why you would suggest recommending multiple people in those regards.
Thank you, Paul. Also, like a very valid question and something, a pertinent topic that one needs to deal with. Even if you do not deal with the administration of your assets, at least look after your protectable interest and most importantly, your children. So in relation to children, there is provision made because we know that the UAE is a melting pot of cultures and is made up of a very large expatriate populace. There is recognition for you to make provision for interim guardianship in relation to minor children. So when I reference minor children, these are children under the age of 21. So in other jurisdictions around the globe, this may be a lesser age, but in the UAE, it is still very much the age of 21. So any child under the age of 21 is considered to be a minor, and you can govern what is supposed to happen with their guardianship. So an interim or temporary guardian can be elected and nominated by you in relation to your will, whereby you say that this person should take immediate guardianship of my child in the event of my passing, and they're authorized to take care of my child and do anything necessary for the well-being of my child. So meaning thereby they can consent to immediate medical care. They can have access to finances or finance something on behalf of the child and have a claim against your estate, etc., a valid claim against your estate for the recuperation of those costs, whatever the case may be. And then also the physical locality of the children, making sure that they are taken care of in the event of your passing. So you can make these provisions in your will for interim or temporary guardianship. And then also following that, you also have to make a nomination for permanent guardianship. Permanent guardianship, or excuse me, rather temporary or an interim guardianship ends as soon as effect can be given to the permanent guardian provisions of a person's will, meaning thereby if a person does elect a permanent guardian, and let's take the example of what happened during the lockdown, the COVID-19 lockdown and the travel restrictions. What happened is a lot of people were stuck here in the UAE, and that circumstances such as that really give validity to the fact of encouraging the appointment of a temporary guardian, somebody that can look after a minor child in the event of your passing and can care for them for as long as is necessary until they can be placed with their permanent guardians. So what we generally do, Paul, and you know this, as by means of good practice, we do this again as a safeguard measure. Even if one parent does pass away, leaving another living parent, and if that person is chosen then to be a guardian, we still elect them to be the temporary guardians, and we still elect them to be the permanent guardians, because we don't want to leave anything up to chance, and we don't want to leave any grey areas in relation to a will. So it will specifically specify those persons, even though it can be interpreted contextually otherwise. It says it in black and white and leaves no room for misinterpretation.
Yeah, and I also agree, and whenever I'm chatting to anyone about this, the recommendation of having multiple, so I would normally suggest at least 3 interim guardians, and preferably couples, so husband and wife, because being in the UAE, we can look at COVID, but we can look at any scenarios that people might be on holiday, people might be out of the country for business, and you don't want to just have one set of people that would be your interim guardians, because then what happens if they're not here?
Absolutely.
Yeah, and I think we've ascertained now that interim guardianship, while it would hopefully just be for a few days, with COVID it could have been for 9 months.
Correct.
So it could have been a very different scenario. And then just as confirmation, the temporary guardians must be here in the UAE for obvious reasons. They need to be able to take immediate custody and guardianship. But then your permanent guardians can be anywhere in the world.
Yes, absolutely. So actually, the temporary guardians needn't be here physically present in the UAE, but we do advocate this simply because of the fact that they need to be immediately available. But let's say, for example, it is a person that is in the UK and can be here within a matter of hours, let's say maybe a 12-hour window from the time that they are notified, then that's also acceptable. But wisely chosen, we do advocate rather to choose a person here, a person that you do trust, a person that is willing to accept such nomination and responsibility in relation to your minor children, and that essentially you feel comfortable with.
But again, looking at the COVID situation, if you're temporary guardians in the UK and they're potentially on a red list,
absolutely,
it's not going to help you very much.
Absolutely. So for practical purposes, I agree with you 100%. They need to be here, but it is not a mandatory requirement.
The other issue that I always try and think about from a practical sense of view is, how are those people in the UK or South Africa, wherever, going to know that you've both passed away in the event that your children are 3 and 4? You know, they're not going to pick up the phone and phone granny in South Africa and say, Mommy and Daddy have died. Correct. You know, obviously it's different with a 10-year-old and a 15-year-old. But, you know, just thinking from a practical sense of view, it makes sense to have someone who is close by, someone that potentially is at the same school. And then it also just comes down to your employer situation, because if we think about the practical sense of you, if you die, the first person that's going to be notified is your visa sponsor.
Yes.
And so they should have a list of contacts and not just the next of kin being your spouse, because in that kind of situation, it wouldn't work.
Right. Absolutely right, Paul. One thing I'd just like to add to this, and which I'd omitted to mention earlier, is that one does have the right to elect more than one person to act as a temporary or permanent guardian, and they can either then act jointly, meaning that they would basically have a 50-50% say in relation to a minor child. Or alternatively, we always recommend substitutes. So person A, if A cannot by means of disqualification, or if they predecease you, etc., then B. If not B for the same reasons, then C. Or you can have A and B. If not A and B, then rather just A, or again, let it go to C and D, or whatever the case may be. So you make those decisions, and you have free right and complete volition to do so.
Okay, well, that's important to know. And then the other thing that you mentioned the other day was that we can also protect unborn children. So you can add an extension to your will, which just makes life easier, that you wouldn't need to pay to update it and all those kinds of things.
Absolutely, Paul. So I've had this situation in the past where, so there is in the eyes of the law, and this is not just here in the UAE, but this is actually in worldwide jurisdictions, there are certain times when a person is actually considered to be a person. When is a person live? And we had a situation where we had an expectant mother with an unborn child, and that unborn child was not a living child as per the law currently here. And as such, then would not be regarded to normally inherit. But what we then did is we brought an aspect to, again, to future-proof her will, and we made provision for any unborn children or future-born children that would be born of the marriage of the two persons who had effectuated those wills. And that was accepted by the authority with that understanding. So again, you mentioned the future-proofing element, and then also for people that wanting to grow families, etc., this could be a viable option, not knowing what's going to happen a couple of years down the line.
Okay, very good. So now I know, and I'm just being conscious of time, but someone has just asked a question about a temporary guardianship letter. And I know a few legal firms used to do those, and a couple of financial advisory firms used to do that, just like a handwritten letter. I mean, does that stand up in court? Is that something that would be accepted, or?
Paul, it's a discretionary thing. So first of all, these letters ideally need to be notarized, but just as a will, if you do not have it properly registered, if such a thing is not registered, it's not set in stone, and it leaves it again up to the interpretation of a court of law, meaning that somebody would actually have to bring a formal court application for the recognition of such a letter before it can be given effect to. That is not only a time consuming exercise, but a very costly one at that. So that is why you have jurisdictions like the Dubai International Financial Center, which does provide for merely a guardianship will, etc., which can be easily done, or then Abu Dhabi Judicial Judicial Department, which can also just provide for you a full will, which governs all of your assets and guardianship provisions included. So again, a letter of guardianship is not a foolproof method of securing the guardianship arrangements of your children, and anyone can challenge that as a letter of wishes only.
Okay, good. So you've touched on it. So can you just run through kind of the different options for wills in the UAE, so the Abu Dhabi, the DIFC, etc.?
With pleasure. Thank you, Paul. So currently there are, very broadly speaking, there are 3 will options in the United Arab Emirates. Yes, I'm going to leave it at 3 because the new personal status law will include the federal law application and only in the Emirate of Abu Dhabi. But let's start with the first one. So let's speak about the Dubai International Financial Center. DIFC has a non-Muslim wills probate registry service whereby they have offered their courts and a specific piece of legislation to govern non-Muslim estates of foreigners within the United Arab Emirates. So one of the key aspects of the DIFC system is the fact that it provides to you the availability of the DIFC court. So it takes you out of the federal courts of the United Arab Emirates, meaning you don't have to make use of the Dubai courts or the Abu Dhabi courts or Fujairah courts, etc. And you make it as part of the Dubai International Financial Center courts only. So the courts there would have jurisdiction to determine all matters relative to your estate. Secondly, that court system is a English court. So it operates in the English language. Its judicial system is an amalgamation of approximately 70% English law and 30% American law. So it's a very westernized type of law that is applied there. It also has different costing. And also different procedural methods that are employed by that jurisdiction. One key factor, however, for the DIFC system is that as of 2019, they had made provision that it not only govern your UAE estate, but it can govern your global assets, if such jurisdiction should recognize that. And what that essentially means, it means that you can draft one will to govern all of your assets globally, and the DIFC will give effect to that will. I must, however, qualify that statement because I advise against the drafting of a global will, and my reasons for doing so are simply the fact that the system has not been properly tested in a court of law. For example, a jurisdiction such as the UK have outright said that they do not recognize a DIFC will, so then you would immediately be disqualified in relation to any property or assets that you do have an interest in the UK in relation to a DIFC will. And this could be the case in any other jurisdiction. You know, we don't know. I know of no matters that have been tested in, let's say, the courts of South Africa or anywhere else, meaning, again, you're opening that door for people to challenge the validity of a will in a foreign jurisdiction. But also from a practical perspective and a logistical perspective, it will be difficult for your family or the executor of your estate to give effect to a will that is effectuated from the Dubai International Financial Center and having it being legally recognized in a foreign jurisdiction. It also involves a whole court process that you have to basically do a transfer, get a judge to hear the matter, to recognize the law, to recognize the validity of the will, etc., and then only get the go-ahead to effectuate that will. So for all intents and purposes, it seems that it is a silver bullet, but respectfully, I must say that it is not. I do appreciate what the DIFC is trying to do, and I mean in no way, shape, or form to discredit the system, but from a practical perspective, it's not advisable to do a global will. But the option is there, of course. I can give you one practical example where I have done a global will for a client. I met a client here in the UAE that had 50 plus companies and did not know what assets he had in relation to each of those companies, and didn't even, the list that we had was not certain as to what exactly or how many companies he in fact had and where they were, where the assets were distributed, etc. So what we did then is in the localities and the geographies that we knew he had assets, we let him do a will in each one of those locations, as well as a global will in the DIFC as a catch-all and safety net option in relation to his estate. And that's the best we can do.
I think
And
that person definitely needs to hire a better executive PA to manage personal affairs.
Yes, of course. So Paul, then just moving on very swiftly, we also have the Abu Dhabi judicial market. So I'm sorry, I keep saying Abu Dhabi judicial markets. My apologies. The Abu Dhabi Judicial Department, the ADJD. ADJD is a federal authority situated in Abu Dhabi. However, they operate virtually, and they allow any non-Muslim foreigner to effectuate a will, a complete full will governing all of your assets and the devolution of your estate, including the guardianship provisions of your children, in a very simple form. They vet the will, and then they register and notarize that will through their authority. The only key differences that apply is that, of course, if there is a dispute or something that needs to be reconvened in relation to a court, it will be then governed by the UAE federal court system. The UAE federal law will apply to that will, and specifically the personal status laws. So, for example, we have the personal status law specifically for Abu Dhabi now, but there is also a federal personal status law. There's a civil transactions law. There are several laws that then apply, but basically these will be the laws that govern the succession of your estate. The main language of the courts is Arabic. So what we do is that we translate your will to read as a bilingual English and Arabic will. However, it is to be understood that if ever there is a dispute in the interpretation of a will, that the Arabic version will be followed by this court. And also it's a very cost-effective option as well, much more cost-effective than DIFC by a vast scale, I would say. And then lastly, it only makes provision for application in relation to your assets of your UAE estate. So anything within the geographical boundaries of UAE, which in my opinion is fit for purpose. It's fit for purpose for me, certainly. And it is the will that I do have, myself and my family do have here in the UAE. Then the third alternative is to have a will that you draw up in the context of the laws of the United Arab Emirates, such as the new personal status law of the Emirate of Abu Dhabi, and that will needs to be notarized by a notary public. The difficulty therein lies, Paul, is that the DIFC and the ADJD systems provide for a probate wills registry service, meaning that they pre-screen your will to vet that it is in fact in order and can be effectuated at the time of your passing. And then also they register it on a non-Muslim probate wills registry. And why this is so important is because if you don't have it registered properly and you only have it notarized, that will need to, upon your passing, first undergo an application to court for the validation of that will, and then thereafter only can procedurally be carried out, provided it is found to be in order.
Okay, so we're basically, the most cost-effective option is to go ADJD, and then you're getting a complete will. And just for everyone who is listening in on this, the cost that we've agreed and that we're comfortable with, which we believe is both reasonable and fair, for a single will, including the cost for collation and drafting fees, the translation into Arabic, as well as the registration fees. With the ADJD, we're looking at about 4,600 dirhams for a single will and about 6,600 for mirror wills. And a mirror will essentially would be for husband and wife. And then if we're looking at DIFC, that cost ramps up to about 14,000 dirhams for a single will and nearly about 20,000 dirhams for mirror wills. And I think the biggest thing there, so with DIFC, you don't have to have it translated, but your registration fees are 10,000 dirhams for a single will and 15,000 dirhams for mirror wills. So that's kind of the key expense that we need to look at. But the benefit of the DIFC over ADJD, would you just say it's really when there is a dispute on that will?
Not necessarily, Paul. It really does come down to personal preference. With a person's understanding of the application of the law, the language that is used, the court system that is available to you, and then also effectively also what interest is it that they want to effect or protect. I will give you an idea. My more high net worth individuals do prefer the DIFC option. And others then also including high net worth individuals also go the ADJD route. It really does come down to personal preference, but what I do ask is that people make an informed decision, knowing the differences and the key differences between the two systems, and then making a decision in accordance therewith. Paul, you can testify to this, is that we had facilitated discussions with a lady whose husband, or a client, not a client, but a lady whose husband had passed away, and she'd gone the ADJD route. She said it was very straightforward, simple. Paul, actually, sorry, I took the information from you, so perhaps you should say it as... No,
that's fine. But yeah, so her husband passed away, and she was able to handle, because they'd had it registered and vetted, with the probate registry, she could handle the whole process post his death, because there was no contest to the will. I think the biggest, just from my interpretation, would be, if there's no contest and you have a standard kind of estate here, you might have a property and cars and children, the ADJD would be fit for purpose, and it would make sure that that is distributed accordingly and guardianship is handled. When you have a more complicated estate, or there could be someone contesting it, well, then if you're having to go down the contestation or route of, anyway, if someone contested and you have to defend that, then I think the DIFC being in English might make that a little bit easier. I'm not sure. I mean, obviously, it depends on the time, but at least then you could have an English advocate who's representing you versus having to have an Arabic advocate where you wouldn't really understand what was going on except for what they told you.
So what I can tell you just from a practical perspective, so it's not necessarily even just having an Arabic versus an English-speaking advocate, but these courts also come with their own cost fees, and the DIFC is known to be one of the most expensive jurisdictions to litigate out of worldwide. So just with that in mind, again, people have said in the past that, yes, although you do pay more upfront now for the registration of a DIFC will, your costs later on are basically deferred. I don't agree with that in any way, shape, or form. I deal with matters on a daily basis of contentious litigation, and these are very costly affairs. But that being said as well, Paul, I don't believe you have any further safeguard in relation to going the DIFC route simply for the language issue, because at the end of the day, a judge is going to be in charge of effectuating the law. As long as we can capture what your testamentary wishes are and accord that with the law itself and make sure that it will stand up in a court of law, there should be no problem.
Okay.
And
awesome.
That's our job ultimately.
Okay. So I know we're conscious of time. I just want to touch on a few key points that we haven't got to yet, but someone has raised this, and it was one of our talking points, was would an SA will suffice for your UAE assets?
Thank you, Paul, and great question. Thank you very much for that. A South African executed will have no legal standing or application in relation to your UAE estate. So for all intents and purposes, it can be disregarded outside of the geographic boundaries of South Africa. So no, unfortunately, it has no validity, and as such, I would recommend wherever you do again have any assets or protectable interests, effectuate a will in accordance with the laws of that particular geography. So in the context of the UAE versus South Africa, have one in South Africa for your protectable interest there, and similarly have the same for your protectable interest in the United Arab Emirates.
Okay, and again, just when it comes to guardianship and stuff like that, make sure they don't contradict each other.
Yes, absolutely.
You don't want your permanent guardian in a South African will to be granny and your permanent guardian in a UAE will to be around a different person. So because then you're going to have someone contesting it on either end or both ends.
Correct. Paul, what I will say in that regard is that they will give effect essentially here and govern your children whom are with you here in the UAE. So again, it's more looking at what are the interests here that you want to protect in relation to this will. So not to worry about that. And I mean, these are the due diligence questions that we deal with anyway for you. So, but yes, good to mention. Thank you.
So the other benefit, I think, of having the wills in each jurisdiction is just that you can also enact them at the same time or simultaneously. So if you had a will for South Africa, for here, for wherever, you can start that process immediately rather than waiting for it to be a decision here and then having it translated and transferred and potentially not accepted in the other courts as well.
Absolutely. So anyone that's ever gone through a process of having to legalize a document either from South Africa for its recognition here in the UAE or vice versa elsewhere in the world, the same would essentially happen here. So even if, let's say, for example, a grant of probate or something is issued in relation thereto, it would be such a pain to have that translated and attested or notarized and legalized by the ministries, and similarly do the same exercise back in South Africa. And again, it's a costly process and it is a time-consuming process, and you don't want to leave that upon your loved ones at a time when they are effectually mourning.
Of course. So now let's getting on to these questions, and I'll see, because I'm nearly done with mine, but I want to spend 2 more minutes, and I apologize that we have run over time. But someone asked the question, which I think is very valid, is with bank accounts. So if the husband is the visa sponsor and all the accounts are in his name, as an example, what would happen on his death?
Thank you. And that is such a great question to ask, because we haven't touched on this issue as yet. So as a default position here in the United Arab Emirates, everybody should please be aware that any joint assets or any assets that are held in a person's name and they become deceased will immediately be frozen. So Paul, you'd earlier mentioned about an employer that receives notification of an employee's passing if they're your visa sponsor. Similarly, there too, the banks receive notification within hours of a person's passing, if not even 1 hour. And by law, they need to freeze your accounts because they have the first right of recuperation of any lawful debts that are owed. And also they are custodians essentially of those funds in relation to any other creditors of your estate. So it is very, very important, please, that if you do have any joint banking account, that or if your husband is the sole holder of an account, we always advise that people please have an account at least in their own name, even if it is just a savings account with a minimum deposit of maybe 50 dirhams, and just keep that as an open banking facility so as to have availability to that banking account when you are in fact in need. And the reason I say this, please, is because it is standard practice in the United Arab Emirates that if, say, for example, somebody does pass away, if a husband passes away, a wife will sometimes go and draw money so that she at least has some access to funds at that time. And in any other jurisdiction where we are not in the wild west here, that would be considered an act of fraud or theft, etc. But here it is overlooked by the police because they do understand that there is that need for maintenance and care, etc., as long as it's properly disclosed and that you are in fact entitled to those funds. So we always say, please go and draw what you can and deposit it into a bank account facility that you personally would have access to. And then also, Paul, maybe you can speak a little bit on insurance, because I can't reiterate enough how important it is to at least have that added safety net, because your savings may not be sufficient, or what you may draw from a specific account before they are frozen in relation to daily limits or etc. will probably not be sufficient to keep a person going for a couple of weeks on end while their estate is administered.
Look, I was always under the impression that that was illegal. So if anyone went and drew cash out of the account, it was an issue, because according to Sharia law, let's say the guy has 100,000 dirhams in the account, if the wife drew 20,000 or 50,000, technically she's stolen from the other heirs because she's only entitled to 1/8, which is
Correct.
13,000 or whatever. So I would recommend against that, and I would rather, and I always say for my clients is have cash available so that you have enough to cover whatever expenses you need to. Also, and we had a similar scenario with another client where he had credit life insurance on his credit card, but she then settled his credit card debt because she didn't want to have any debt, so she settled it, where the credit life insurance with the bank would have settled those amounts. So you know, it is a very emotional and difficult time, and you know, having to make decisions quite quickly. But that's why if you have a will in place, you have the credit life insurances with the bank on your vehicle, on your mortgage, and on your credit cards, you know, at least then it covers those. So don't worry about those kinds of things. But yes, definitely from an insurance perspective, having sufficient life insurance to cover future expenses. And I mean, education in the UAE, they say, is 1 million dirhams per child, and that's only going up. So making sure those kinds of things are covered through your insurance policies, have those set up outside of the UAE. So take an international insurance policy that can then pay anywhere in the world directly to the beneficiaries. Again, that's then outside of Sharia law. If you have beneficiary nominations, it doesn't have to be part of your will or your probate process. So that'll pay directly to any bank account.
Yes.
And having that set up. So agree, definitely have your own separate bank account. I recommend against having joint accounts in the UAE just because they can be frozen. And then, you know, having that insurance policy in place to pay out, it makes such a difference. And I've even seen some scenarios here where, you know, people say, well, I've got life insurance with my company, but I've seen from a very big employer here, their insurance takes 12 months to pay out.
Yes.
Who has enough money to last them for 12 months without an income, if one of the spouses is the sole breadwinner?
Right.
So definitely have that individual insurance in place and have that set up properly with beneficiary nominations. And one of the providers internationally, you can even have contingent beneficiaries. So if, you know, husband and wife were to pass away together, you could have a next layer of beneficiaries, which is quite smart.
Wonderful. Yes. So these options are available, Paul. And listen, you know, realistically speaking, these are considered nice to haves as opposed to must haves. And even personally speaking, you know, Paul, being frank, you know, just relaying this as a fellow human being, I've told you myself in my personal capacity that I need to start, you know, really actively looking at these things. And I know better than most people what can happen. And, you know, sometimes funds and things are a little bit shy, and you don't always have the luxury to do this. But factually speaking, it is something to consider and to be had. So whatever arrangements you can make for the safeguarding of your family and loved ones, please do so.
No, agreed. And so I want to just look at one or two questions so we can wrap this up.
Please. If I may also just invite everybody, Paul, they do have your email address. So if there's any questions that they want to relay to us here and after, you know, we'll be so happy to have a further discussion thereon, because I think we may have mentioned a couple of things that have sparked a couple of, you know, thought-provoking ideas for people. So we welcome any questions, comments, feedback, anything.
Yeah, thank you for mentioning that. So, look, I can't see any. I mean, someone just asked about a Saxo bank account in Denmark that he opened from here. I think that depends where that is domiciled. So if it's, because I know Saxo just has a sales office here, so your funds will actually be sitting in Denmark. So technically that's outside of the UAE. Your UAE won't have any impact. But then, I mean, I'm not 100% familiar with Saxo, but do they allow you to nominate beneficiaries or have something like that? And I think, Chris, you need to just ask Saxo what would happen and how that would be handled. I have heard feedback from one or two brokerage accounts where they say, you know, they'll accept a will from any country which says how they must distribute the assets. But obviously your court order here isn't going to say, okay, Saxo must pay it to these people. It would be a slightly different approach. Yeah? Is it fair to say the last will stand the most current, and can we do one here with you for both? So yes, we can sort out both your SA and UAE wills from here. And if you have an existing will in South Africa, the new will replace that. Yes. The clauses included in the will to specify that, and that previous wills become null and void. And then obviously the UAE will, we'll go through and get that properly registered here. So that would be the official will for your UAE assets. So I think if there are any other questions, if I have missed any, I do apologize. Please do email that through to me. I will make sure we can get that answered for everybody. And I will be putting this up on YouTube and then link it to WhatsApp and stuff like that soon. Give me a few days. I just need to clip it and mark it. And but a special thank you, Luna. Thank you very much for your time. I know it is the evening. I know you've been away from Andrew and your fur babies, but your knowledge is invaluable on the topic, and I think it has really helped a lot of people that we've been speaking to.
Paul, thank you so much, and I'm always grateful. I always say that I'm so grateful to be working with you, and this is what clients have iterated to us time and time again, that you know, you really do take care of people. So thank you to you for your valued contributions always, and always going the extra mile for our clients. Thank you. What a pleasure. Thank you to everybody for having joined and sparing your evening for us. It was lovely having you in our company, and yeah, we look forward to hearing from you.
Awesome. Thank you very much. I'm going to turn off the recording, and then we will be just closing down the session. So thanks a lot, guys.
Thank you, everybody. Take care. Bye-bye. Stay safe.